Another thing that comes to the fore, and we have this happen relatively often, is the idea that employers are talking to employees, and employees are saying, you know, I don't feel that I need to provide you with any information for this kind of leave. That's not quite right, and we're going to get into that in a moment. We talked about the paid sick leave issue. Let's talk briefly about the FMLA issue. So the emergency family leave provision provides an additional 10 weeks of expanded leave to care for a child if the child's school or child care provider is not available. And again, you can't force an employee to go to some child care provider that they never met, right? I'm sure you wouldn't want to do that with your own child. Just send them somewhere that you hadn't talked about. So this talks about the idea that the person has a regular child care provider and that child care is not available. So what kinds of things can an employer ask for and expect? I've literally had employees tell their employers, I'm not providing you with anything. First of all, if they don't provide you with anything, you're aware of the fact that the Families First Coronavirus Response Act allows for you to receive dollar-for-dollar credit on your payroll taxes. And the only way you're going to get that dollar-for-dollar credit is if, in fact, you have the appropriate information to go ahead and request that dollar-for-dollar credit. And that information is as follows. So first of all, you can request information like the employee's name, the dates leave is required, and stuff that will allow you to review the reason for the leave, right? Information that explains why it is that they're going out, so they're subject to quarantine or it's a child care issue, whatever. And then next slide, please, Brooke. So once you provide that information, if you're subject to quarantine, the employee has to go ahead and provide the name of the government entity issuing the order. And then if you're advised to self-quarantine, the individual should provide the name of the advising provider. So whoever it was that advised that person that they should be self-quarantined, you need that information as well. And then if they're seeking symptoms or experiencing symptoms and seeking a diagnosis, there's no additional information required. If you're caring for an individual who's subject to a COVID-19 quarantine order, then here's some of the things you can ask for. Brooke, please, next slide. Okay. The name of the individual, the employee's relationship to the individual that they're caring for, and then who ordered the quarantine. And then finally, in the child care related absence issue, a few things. First of all, the name of the school where the employee's child is going, the name and age of the child, and a statement that no other child care is available. Now, that's sort of interesting, right? Because I've had a number of people say to me in the past, well, I have employee X, his wife actually lives at home, so why is it that he needs time off right now? And that employee then invariably says something like, well, my wife is not well, and therefore I have to care for the child, et cetera, et cetera. And that's pretty much on the honor system, right? I mean, there's not going to be a way that you as the employer know that the individual is the only person available to care for the child, but you do need them to make that statement. And then if the child is over 14 years of age, they need to express the reason that they need to care for a child that is that old, because obviously the child is capable of caring for itself at that age. So what do we do if an employee refuses to provide this information? First of all, you should record all this information on some sort of form. If you do not currently have a form, you should create one requesting leave. And then once you get this information, the employee should fill it out before the employee goes on leave. If the employee goes on leave and takes off and has not filled this information out, you are not required to pay them, and you're not required to honor that leave process. So you literally could start the attendance process, right? I mean, look, nobody's looking to give anybody a hard time here, and people certainly understand that there are going to be reasons why folks can't come to work. But there are from time to time people who take advantage of the system. And again, if you hope to get paid and get reimbursed for the payments that you're making to these individuals, this is information that you need to be able to have. I've also had people ask me about how often they can request updates, right? So we're aware of the fact that now that we're in green, childcare is open again. So how is employee X telling me that their child is in fact not able to obtain childcare? Well, you're probably familiar with the fact that even though we're in green, child care facilities are restricted as to the number of people that can attend. And as a result, it is possible that child care is open, but your employee can't get in there. So how often can you ask for an update? If it's FMLA, the 10 weeks of FMLA leave, you're allowed to go ahead and ask for an update every 30 days, right? So once the employees fill the information out, you can go back to them in 30 days and say, have you been able to find childcare yet? And they can go ahead and respond that they either have or have not. And we can work with it that way. Next slide, please. So what if an employee won't provide the information? Again, ultimately, if they won't provide the information, you could go down the road towards discipline and termination. All of this can be avoided if we simply get that information up front and make sure employees know that we need the information rather than sending somebody out and then later trying to get the information from the person. And that makes it much more difficult. So what about unemployment compensation eligibility? If a person refuses to return to work when work is available, then that person is not ready and available for suitable work and therefore is not eligible for unemployment compensation benefits. On the other hand, to the extent that a person is home because of a shortage of work or something along those lines, they may well be able to get unemployment compensation benefits. Immigrants and visa holders are eligible for unemployment compensation benefits based on a couple of things. Number one, the status that the person was in during the time that they were working, and you're aware of the fact that to qualify, a person has to have 4 out of 5 qualifying quarters. But was the person in legal status at the time that they qualified, that they had those 4 out of 5 eligible quarters? And then secondarily, their status at the time of the request. So when they request unemployment benefits, they must also be in legal status to work. What all that means is that to the extent that you have people that are being laid off, et cetera, those are people who really ought to be told about the unemployment compensation process. You're probably aware of the fact that Pennsylvania now has a form that you must provide to all employees that you're laying off or terminating. And again, that should include the visa holder folks and the folks who are here as immigrants because benefits may be available to them. So what about some other kinds of things? Brook, next slide, please.
Oh,
the wearing of masks is obviously something that has created quite a little fervor amongst folks. There are people that seem to have a great deal of difficulty with the idea of wearing a mask. From the employer's perspective, of course, it's important to recognize that the governor's order talks about the wearing of a mask and allows for customers and things like that to be allowed to not wear a mask to the extent the customer simply says, I'm unable to wear a mask. So if you're running a farmer's market or something like that and you still have customers that are coming to you, those people need not wear a mask if they simply say they have a health condition. You're not required to look behind that transaction, nor are you allowed to ask them for additional information. On the other hand, if an employee is to say to you, I have a health condition that keeps me from wearing a mask, what is an employer to do? Well, first of all, we have to understand that anytime we start to talk about an employee's health condition, we may well be discussing the idea that that employee is entitled to an ADA accommodation, right? So we start the interactive process with the employee and begin to talk about why it is that the individual needs to not wear a mask or has difficulty with wearing a mask and what potential options are available. So you've seen face shields out there, those clear face shields. There are some people who have told me that their employees have an issue even with that. To the extent that we have a situation where an employee's doctor provides that the employee may not wear a mask at all, there are some other kinds of things you want to consider, like potentially putting up barriers around the employee, putting the employee in an office where the employee can work. And again, as an agricultural worker, that's not easy to do, right? So perhaps we could distance him considerably further away than other employees. But again, to the extent that a doctor says that the individual can't wear a mask and they provide you with that notice, a couple of options. One of them is the employee goes home, and the other one is that we try to make some other kind of accommodation, like spreading the person fairly distant from the next person. Now, if we're running a packing operation, it may be a little bit easier, right? Because we could probably barrier the person off with plastic and things along that line. But be aware of the fact that that ADA requirement still exists if an employee can't wear a mask. Another thing to consider about mask wear, and the state government does address this issue. When you start to talk about mask wear, you also have to be mindful of the fact that a lot of people are working outdoors. They're working outdoors in temperatures that can climb to, mid to high 90 degrees levels, right? And I will tell you right now that things like heat exhaustion and heat stroke are much more of an immediate problem to an employee working in those conditions than might the coronavirus be, for example. So I will say to you that to the extent it's extremely hot, you can, in fact, say to employees, you're allowed to remove your mask. Again, we should try to keep them separated as much as possible to ensure that we have social distancing. To the extent that there are common areas that employees might use, so break areas, lunch areas, soda machines, things like that. Those things all need to be frequently cleaned with appropriate cleaning materials. And then, of course, advising employees about frequent hand washing. So all these things are in place. One of the things I will tell you is you have a requirement to be able to say that you have spoken to your employees about these safety issues and to provide them with information that ensures that they are aware of all of these practices that are designed to cut down on the spread of COVID-19. So you should be talking to your people about this to the extent that you have morning briefings or anything like that before your people go out to the fields. Those are things that you want to talk about as well. Next slide, please, Brook.
Okay.
So we talked a little bit about this, right? The idea of masks, and again, it says on that very first bullet that masks should be worn when social distancing is impossible. So pretty much the new governor's order talks about masks being worn at all times, unless, of course, you're sitting in a place where you are sure that you're not going to come into contact within 6 feet of another person. And again, how can you really be sure of that, right? Well, one way, of course, if let's say you've got truck drivers that are delivering product to a location and the truck driver is in the vehicle by himself. Does he need to wear a mask in that instance? No, he does not. When he gets out to help unload, on the other hand, he would be wearing a mask in that instance. People who you may have in your office, maybe working in your finance section or something else, those people, if they are in an office and they're in there by themselves, do not need to wear a mask. If they're out in a public area, however, of the building, they should be wearing a mask. We talked about those other two bullets, customers versus employees, and the safety exceptions for employees. We've already discussed that issue. So let's look at the next slide. We have talked about the heat exhaustion, heat stroke concern, and I will tell you that there is at least one study that talks about temperatures of 84 degrees and higher being high enough to be able to say, okay, mask wear might be problematic here and dangerous for employees, so be aware of that fact and consider that your safety people are paying attention to the temperatures as we go through this process and the employees are attempting to work, okay? Next slide, please, Brooke. So again, we want to ensure that employees have incentives to stay away from each other, right? So we don't want 10 guys standing next to each other smoking next to the tree out there in the field somewhere. If they have to take a smoke break, you should make sure that even then they're ensuring that they're socially distanced, right? More than 6 feet away from the other person. And of course, if you're actually smoking a cigarette, you're probably not wearing the mask, but when you're not smoking it, you have that mask on. Consider the idea of weekend work if you have not done that already, and shift work. So if you do not already run multiple shifts, we're in the period of time of the year where days are longer, and it is entirely possible that you could switch your employees up so that you don't have all the people showing up to work at the same time, and that there's limited overlap so that you don't have issues as far as social distancing is concerned. And then again, we talked about the idea of frequently cleaning any kind of common area like a lunch area or a break area. I talked about soda machines earlier, and I don't know about you guys, but I get like so upset when I go to the grocery store and I need to, punch the pin pad on the ATM machine there, and certainly no one's wiping that thing off, and you just kind of feel weird about it, right? So you want to make sure that to the extent employees have access to soda machines and things of that nature, they are being cleaned, and they are being cleaned at a level that is more frequent than had been in the past. Next slide, please.
Okay.
So even in our offices, we have shut off all visitors. So I think our first visitor came in on Friday of last week, and it was sort of interesting to finally have somebody in the building. But that was an exigent circumstance. We do not have our building open to visitors, and you should not either. So to the extent that you had tours or anything else that was going to happen, those things, if they're not canceled already, should be canceled. You shouldn't be allowing visitors into the process until your facility unless you need them. And then we talk about partitions for those in proximity, right? So to the extent that somebody's close to their workstation's close to a walkway, perhaps in a packing area or something like that, we want to make sure that they are still partitioned off from that walkway so that when people are walking by, they're not in that close proximity to the individuals just because of the workstation that they're in. And again, cleaning common touch points is a little different than the common areas. So doorways, entrances, anything like we talk about railings on stairwells, all those kinds of things need to be frequently cleaned as well. all right? And then next slide, please, Brooke.
Yep.
So what about temperature screening? Temperature screening is not something that is required. It is something that is allowable right now because of the global pandemic. A couple of things that I'll say to you about it. To the extent that you have a person that is experiencing a temperature of 100.4 and higher, that is something where we would go ahead and exclude an individual from the workplace. I will tell you as well that I have recently seen studies that talk about the fact that a little bit more than half of COVID-19 patients do not experience that 100.4 temperature spike and instead experience some sort of loss of sense of smell. So, I mean, that's interesting, right? We have this tool in our toolbox of taking temperatures, but it may or may not work based on, how people exhibit symptoms. Again, we're still doing the best we can here, and if you want to take temperatures, it's not a bad idea. A lot of people I talk to talk about the fact that they're using their supervisors to take the temperatures of that supervisor's employees. I would recommend against that. Your supervisors are not authorized to have medical information about employees. And as a result of that, I would suggest to you that if you have various supervisors for different groups or whatever else, that you would switch those supervisors over. So one supervisor takes temperatures for people who are not in his group, while another supervisor takes temperatures for that person's employees, right? So we're switching them over. And then, of course, contact tracing. So to the extent that we do have a positive test, we want to go ahead and make sure that we are aware of whom that individual that has the positive test was in touch with, and to the extent that they were in touch with anybody for 10 minutes or more closer than 6 feet, we want to go ahead and touch base with those people as well and find out who they've been exposed to. You're probably aware of the fact that to the extent that you have employees who've been in touch with a person who is a potential positive, and you are a person who, or a business who is an essential business, your employees can still come to work provided we're following certain guidelines, like taking temperatures, asking about symptoms, things like that. So when it comes down to essential workers, the mere fact that you've had contact with a potential positive does not mean an employee can't come to work. That having been said, to the extent you can do without that employee, I would suggest you do so, just to ensure that you're keeping employees safe. Now, Brook's going to talk in a bit about OSHA, but OSHA's general duty clause requires that we keep employees safe from recognized hazards in the workplace. So to the extent that we have a potential hazard because somebody has a case of COVID-19 and has come into contact with another employee, and we're ordering that employee to come to work, there may still be issues that can arise because of that, right? Mandatory testing. Next slide, please, Brooke. So when you start to talk about mandatory testing, a couple of things. First of all, if an employee does travel someplace, in spite of any travel restriction you may have, you would probably want to go ahead and direct that employee to take a test. And of course, after the employee has had an exposure to COVID-19, they should be tested as well. I've had some employers tell me that they have access to lots and lots of tests, and so they're asking, should they test everyone? And the answer to that question is, much along the lines of what you hear all the time on the news media, right? So can every employee test or every person get a test just because they want one? Well, whether or not they can, the question is, should they, right? So should you be testing every employee just because you have the ability to test? And my answer to you is, unless you can have the ability to test the employee every couple of days, then it makes zero sense to test the person who has no symptoms or whatever else, because you're testing them for right now. The person could be negative right now and tomorrow come up positive. So unless you're going to have consistent testing, just testing everyone across the board makes little sense. Next slide, please, Brooke. So again, employee travel restrictions. People are talking about, are these restrictions lawful? And I will point out to you that yes, they are lawful. They're part of a health directive because of the global pandemic. Those health directives have existed in the past. Some of you are aware of various outbreaks that have occurred in the past, like, for example, the polio virus that existed for a while and crippled many, many millions of Americans. There were health provisions that were put into place at that time. So yes, state governments can put these kinds of rules into place. What about if an employee won't comply with a travel restriction? Well, we talked about that. You could decide that you were going to suspend them. You could decide that you weren't going to allow the person to come to work. And then, of course, there's the issue of, do we need to make that payment that I talked about in terms of the paid sick leave, right? And then how would we know of travel? if we know an employee is about to go on leave, we should be touching base with that employee about where they're going and what it is they intend to do while they're there, right? Next slide, please, Brooke. So what are the questions that we ask of an employee when they're returning to work? First of all, what their own symptoms are, and have they had any symptoms of COVID-19? And you might want to include that sense of smell test that we talked about, asking whether or not they've had any noticeable loss of the sense of smell. And then what contacts they've had within the last 14 days, right? This is the kind of information we want to elicit from people when they're returning to work. And then reporting of a positive test. Next slide, please, Brooke. To the extent that we have positive tests in the workplace, who do we need to report these tests to? We should be reporting them to close contacts. We do not need to report them to health officials, because the persons taking the test are the persons who are doing that reporting. So if you are the person taking the test, then yes, they should be reported to public health officials. But if somebody's testing at their doctor or whatever else, that information is going to be provided to them, right? And then do we need to tell the public in general that we've had a coronavirus test at our facility? The answer to that question is no. We do not have that requirement. And then cleaning after positives, I like to say the solution to pollution is dilution. So to the extent that you have a positive test and it's an employee who works outside, it's constantly being diluted by the air, right? So that's good. But to the extent that somebody perhaps in a packing facility gets it, we need to open that facility up, air it out, and make sure that we have the ability to keep it nice and aired out for a good 24 hours before we go in there and attempt to clean. Last thing, last seminar, I talked about the fact that we had a couple of clients who called us and said that they had been contacted by the Department of Agriculture, Pennsylvania Department of Agriculture, because they'd had positive tests. And they were asked to fill out a survey and asked to allow the inspector to conduct an inspection. When I was done talking about that, a representative of the Department of Agriculture mentioned that they have only done that in cases where the Department of Health has told them that there have been an inordinate number of COVID-19 cases in an area, and that happens to include one of our employers, and that they say they've done that very infrequently. I will tell you that the representative also went on to say that the on-site inspection is voluntary on behalf of employers. So again, to that, if that happens, you get contacted by Department of Agriculture, you can fill out the survey and all that sort of thing, and then talk about the voluntary assistance that they would provide you. They would want to do a walkthrough and give you any tips that they might be able to help you with COVID-19. All right, and then finally, down at the last slide, there's no evidence of foodborne disease at this point when you start to talk about COVID-19. You are required to have COVID posters posted, and you should make sure that poster is posted within your facility. Social distancing is important, and to the extent that we have meetings or things along those lines, we should not have meetings of 10 people or more at one time. So if you're going to go into the conference room and have a meeting, make sure that you keep those numbers under 10. We talked about educating employees, making sure they understand what's important and that they are to keep themselves safe and how they can keep themselves and their coworkers from the likelihood of contracting this deadly disease. And then we talked about post-positive testing by Department of Agriculture. So having said those things, Brooke, I will turn this over to you at this point, and we will be available for questions at the end.
Okay, thanks, Schaun. Yeah, for all of our attendees here, I will work through my subject areas, and then whatever time we have left inside the hour, we'll devote to questions, or you can hang around for a little overtime session where we can have questions and answers. All right, introduce myself previously. I have 3 slides here that reiterate and provide some resources regarding the Families First Corona Response Act, which again is the act that provides the various types of paid and unpaid leave for those who are under some type of quarantine order or need to take care of a family member, child, etc. So these are just some resources on that. Schaun talked about that. When you need more resources, anything that's in blue here is obviously a link. Hopefully people are familiar with that concept. And it's just, here's 3 slides that tell you information about that. Schaun did mention a poster. There's 2 posters under the law right now that every employer is required to have posted. The first is relating to the Families First Act, and here is a link to that poster. The second I have a link to later on in the presentation. If you get those 2 posters, you're in. You made your poster requirement in light of COVID-19. The second of them is from the Pennsylvania Department of Health, by the way. So this is the only federally required COVID-19 poster, and then there's a Pennsylvania Department of Health required poster. Okay, now here's some more resources regarding the Families First Act again. By the way, if you've never explored this website, there's a website from a group called the Farm Employers Labor Service, and it's actually a offshoot of the California Farm Bureau. It's California-centric, but they have so many good resources in there and so much to offer that you really owe it to yourself. If you're in this line of work and you're an HR person for an ag-related business, this is a great, great website. All kinds of great resources there. If I have an asterisk next to a link, that means it's really the best of the group that I'm sharing with you. Okay, let's talk about unemployment. Although it's not necessarily these changes for the employer side, it's good to understand, and it's just another thing that you can say, okay, I understand that part, therefore nothing is slipping by me. You're on top of what you need to know as an ag employer. These are basically acronym heavy. There are 3 specific unemployment programs that have been cobbled together through the various Families First Act, the CARES Act, and there is the Pandemic Unemployment Assistance, the PUA, which is the expansion for people who are traditionally not eligible for unemployment. Then there is the PEUC, which is the Pandemic Emergency Unemployment Compensation Program, which is adding 13 weeks to the traditional 26 weeks of maximum unemployment that an individual can collect. And this has a time limit. It runs to December 26th of 2020. And by the way, the Families First Act leave provisions also have a time limit towards the end of the year, and it's on the slide, one of those slides that I previously put up here. And then there's a third, this is the federal benefit, where the federal government provides the extra $600 per week, and that's called the FPUC, Federal Pandemic Unemployment Compensation. So if you ever see these acronyms, now you know what they mean. And these are the 3 separate unemployment changes that were caused by COVID-19. And there's not actually a specific site that I could find for the extra $600 a month. That comes directly from the federal government to your employees, or by the way, or ex-employees. And these other 2 are state websites that explain it in detail. So, and here's some more links here. So that's the unemployment changes. I want to show you something that's on the Pennsylvania Department of Labor and Industry website, which is a great tool for testing your knowledge to see if you have a working understanding of the basic provisions of the Families First Act, the unemployment situation, and also there's a column for workers' comp. What this thing does is, it's a very nice document, and here's a link for it. It sets forth various scenarios that an employee could be in the middle of, a set of circumstances. And then it goes across the columns and tells you essentially by check marks or the X's, what benefits they may be entitled to. And if you can sit and read this document and anticipate the answers and get a basic understanding of where the X's and where the checks should be, you're on top of it. That tells me that you have figured it out well enough that you should be confident that you have the working knowledge that you need as an ag employer to be able to juggle all of these things. My point of my entire presentation really is you got more important things to do than be juggling these things in a normal scenario. Now that COVID-19 is upon us, these things start to creep up there in importance. And if you can negotiate this chart and get a basic feel for it, you're making headway on having the skill set and the knowledge set that you need to feel good that you're on top of things in this sort of crazy environment that we're in. Okay, now this is what I want to talk about in a lot more depth. When is a COVID-19 diagnosis work-related? And before we go on to talk about what's below this, I just want to pick that apart for a second, which is somebody shows up at your workplace and they end up with an employee of yours, and they end up with a positive diagnosis for one reason or another of COVID-19. The big question starts to become, well, where did they get it, and how could anyone ever even prove that they got it in a work-related situation? And this could be important for the purposes of workers' comp reporting. This could be important for the purposes of OSHA reporting, both of which we'll talk about a little bit. But it's also important for this other thing that everybody really seems to be obsessed on. And, it needs to be sort of examined, and perhaps the bubble burst a little bit and make it a lot more comfortable and easy for you as people who are not versed in, liability questions. Why everyone's talking about liability, but exactly what are they talking about? You have legislators talking about, oh, we need to provide liability protections. What exactly are they referring to, really? Now, there's two potential categories that perhaps they're referring to. One is transmission to employees. In other words, some type of liability by an employer for transmission in the workplace to its own employees, or contraction of the disease to its own employees. Then there's a separate issue, which is transmission or contraction by third parties that in some way is related to your workplace, or that someone might claim is related to your workplace. Okay, the media accounts have been around, talking about employees who file lawsuits against their employers. And the one that has probably been, well publicized here in Pennsylvania is the very first death of a meat processing plant employee of COVID-19 occurred right up in Montgomery County at the JBS plant in Souderton, Pennsylvania. And that employee's family immediately sued JBS. Well, that was a product of completely 100% creative lawyering. That is not the rule, that is the exception. And in fact, I'll, probably, not going too far to say that the courts are going to handle this. And I think the chances are extremely good that this will that this lawsuit will be dismissed at some point in time. Just a matter of time. So all of this stuff that you hear, that people seem to like to trade in, these stories of employees suing employers because they got COVID-19 in the workplace, it's not a thing. This is the product of some extremely creative lawyering that has little to no chance of succeeding or going anywhere. The courts will handle those things. And why is that? It's not going anywhere because we all were born and have lived our entire lives in the world where workers' compensation is legally required and is, in fact, the exclusive remedy for any employee's injury that they may have received in the workplace in the course and scope of their employment. Now, the basic tenet of workers' compensation is, in exchange for having employers provide this and be required to provide this by law, there's also the corresponding immunity which employers get from claims of injury or illness against their employer. So workers' compensation has always been and will continue to be your 100% protection from claims of workplace transmission to your employees. Now, wait a minute, let me go back. Not only do you have this legal immunity from these claims by virtue of the Workers' Compensation Act, but think of it this way, which we talked about at the outset of this slide. How is anybody going to prove that the workplace is where they got it? Could have been at the gas station on the way home. It could have been on the doorknob at the restaurant or the fast food place. Could have been at the pizza shop where they stopped in to pick up their to-go order. It could have been, depending on where you are and who's open for business. It could have been any commercial establishment into which you stepped. It could have been any social interaction that you had. It could have been a family member. It could have been somebody you passed on the street. It can be anywhere and in almost any scenario, and proving that somehow just because you might have one or two employees that have a positive diagnosis and then another one comes up, somehow they're connected to each other and one was caused by the other. It's not a thing that is in any way, shape, or form ever going to be easy to prove in a legal setting. So just be aware that that is the first and foremost problem, even apart from the workers' compensation legal immunity, that any employee would have in asserting a claim of that nature. Yes, there could be employment scenarios where maybe you have a work cohort of 5 people that are always working together because you're doing what the CDC has told you to do in terms of segmenting your employees like that so that they don't have intimate contact with a large number of people, and that you have sort of their contact tracing becomes easier because they only work with these 5 people, whatever it may be. Even if the cohort is, all, is showing many positives, still proving causation is a gigantic legal hurdle. And your workers' compensation carrier, for the most part, although the guidance has been, go ahead, handle your cases, your diagnoses in your workforce if you have them. Report them to your workers' comp carrier if the employee is demanding that. But the first issue that your workers' compensation carrier is going to assert is how, in fact, is this ever proven to be related to employment? You could have been contracted anywhere. And just be aware that workers' compensation, in terms of the terminology, contracting COVID-19 is being dealt with as a workplace injury, not a disease. Occupational diseases are a totally separate thing, and that's not what COVID-19 cases in the workplace, even if an employee is pushing it and you end up, you do report it as a workers' comp reportable injury, it's an injury, not a disease. Occupational diseases are something separate. Nurses and healthcare providers, perhaps COVID-19 could be classified as an occupational disease, but not in other contexts. Here's some resources on workers' compensation, by the way, in dealing with COVID cases. And again, as the employer, your primary responsibility is, if the employee is presenting it to you as it's work-related and you have some potential contacts between this employee who's got the diagnosis and perhaps another employee that had the diagnosis, or another set of employees, plural, who had the diagnosis, perhaps you report it as a workers' comp injury. Best thing to do is contact your workers' comp carrier, walk through the whole scenario with them. That's what you pay the premiums for, and act as they direct you. Sorry. Okay, now, liability to third parties. Let's talk about that, because that's really an issue that is going to grow and grow as time goes on. So this is anybody other than your own employees, and the fear that there's somehow liability concerns to other persons, and in an ag context you might have customers in a direct sale context, or delivery people that visit your work site for whatever reason it may be. Good thing, obviously, to start with is there's no foodborne transmission that has been scientifically identified to this point. So we're not dealing with that kind of situation. If we were, we'd be in a much different world right now. But what applies in this kind of a claim, or this type of an instance, just to sort of calm your nerves about liability concerns? Standard negligence principles apply. Standard negligence principles say, did you act with reasonable care towards others so as to prevent any type of injury or damage to them? And reasonable care is a definition, or a word that does not have a concrete definition. It depends on your particular circumstances. Now what needs to be proven in order to show negligence is that an employer or a party, whoever it may be that you're discussing, has somehow fallen below the standard of care that it owes to others to protect them against injury. We also need causation, which is that in fact, whatever the incident may have been, or whoever is being blamed for transmitting the disease, that's in fact where they contracted it. And so you have that causation question coming up all over again. But let's talk about this standard of care in a negligence context. And I'm giving you this so that you have some concepts to deal with, to hopefully calm people's nerves about this. Where would you get the basic principles of how you act with reasonable care towards others in the prevention of the transmission of this disease. Well, they call that the standard of care in legal terms. Well, you'd get that from, there are no concrete, permanent written government guidelines on how you protect others, but there are a lot that have been, temporarily put in place or have been recently put in place. How long they stay in place and what they're replaced by later might be another question. But the most important one is the one that hopefully everybody's aware of, which is the CDC OSHA guidance that came out in May, which is for agricultural workers and employers. This is, if there's one document that is the primary guidance that you need to know, and when somebody says, well, what are you doing to provide a reasonable standard of care towards others, that they do not become somehow infected by dealing with your business, you're following the CDC OSHA guidance. So that's the first thing that you have. Keep clicking here and advancing by mistake. That's the first thing that you have in your arsenal. So you need to know this document. There's no question about it. If you're not familiar with this document, get familiar with it. It is the talisman of this entire effort to try to keep this disease under control in the agricultural environment. CDC put out many for other workplaces. They delayed a bit in getting agriculture one of their own. Now it's out there, and you need to be using it, employing it, and doing the things that it says. I put a little asterisk down here because, well, if you aren't doing these things, are you negligent? Well, that's that's not a concrete yes and no answer that can be given. Depends on individual circumstances, but it's certainly a good indicator that you're not negligent if you're doing all of these things. Now, the next important document is there's the CDC's critical infrastructure guidance, which came out before the ag worker and employer guidance, but that's also a very important one. And then the ag worker and employer guidance talks about preparing a COVID-19 assessment and control plan. And if you ever looked at this agricultural employer checklist, it's on the CDC's website, it just about writes your COVID control plan by the mere act of completing this checklist. So if there's something that, I would say is the second most important thing to do, read this document for workers and employers and do the checklist. Then you're going to have some basic conversational familiarity with the things that you need to be doing to show that you're not negligent. That's essentially what it is in a nutshell. Now, in addition to these CDC guidances, there are also the mandatory Pennsylvania orders, which you better be conversant with and complying with if you want to show that you're basically being non-negligent, that you are protecting those that your business comes in contact with from the potential that they could somehow contract the disease in dealings with your business. There is the May 4th COVID-19 guidance for businesses that the Pennsylvania Department of Health has issued, and that's a mandatory order. These are all mandatory orders. The CDC are advisory or recommendations. There's also this one, the May 4 guidance for businesses has the second poster requirement. I showed you the poster requirement before for the Families First Act. Here is the second poster requirement that everybody has in Pennsylvania, which is this COVID-19 safety procedures for businesses. So that's poster number 2 that you're required by law to have. There's the April 19th order, and that's the principal one that when ag was recognized as critical infrastructure and was permitted to remain permitted to maintain in-person operations, this is the document that is all based on. And then there's a somewhat earlier one from April 6th, which is talking about essentially building safety measures, which talks about your physical structure and your physical facility. So these 3 together are the things you need to know and comply with that are coming from Pennsylvania. And again, these are mandatory as opposed to the CDC documents that we talked about before, which are actually all just simply recommendations and guidance. Okay, lastly, just want to mention that in order to best avoid negligence claims and show that you're using your best practices, the Department of Ag, of course, has their list of guidance. And again, these are all recommendations and guidance documents. The one I want to draw your attention to is the very last one is has a slightly misleading title. It says modifications to seasonal farm labor camp requirements. However, this is a much, much broader document than that. This is for any production agriculture. You need to read this document, even if you don't provide any housing, because it deals with the day-to-day operations of agricultural production environments. So just know that this has a little bit of a misleading and restrictive title. All right, we are at noon, and that is the advertised time that we were going to allot for this webinar. However, with your indulgence, I am going to continue on. I see that we've lost a few people who have signed off. Again, make sure that you send us your email and we will send you the PowerPoints, and that will hopefully give you lots of good resources. What I've included in here is some guidance that OSHA has provided. Just like you may have a situation where you need to report a COVID diagnosis to your workers' comp carrier, there also starts to become the question, when do you need to report a COVID diagnosis to OSHA as a work-related injury? OSHA has provided guidance for this, and here are links to it. It's not the easiest thing to apply in real life. It may not be the most practical thing for somebody who's trying to keep their business afloat to try to apply this. However, just know that OSHA has in fact provided guidance on when a positive diagnosis in your workforce may need to be reported as a work-related injury for OSHA purposes. And lastly, I have included this document that is on the EEOC, Equal Employment Opportunity Commission, website, which is called What You Should Know About COVID-19 and the ADA, the Rehabilitation Act, and Other EEO Laws. This document could not calm your nerves more, I will say, if you are an employer who's unsure about what you can and can't do with regard to temperature taking and testing and what kind of testing and when. All of those various scenarios are dealt with in this document in exhaustive detail. If there's one document that you consult to get yourself feeling that you have some degree of command of, are you doing everything right with regard to particularly the ADA, because this is now, if someone has a positive diagnosis, then there is a recognized medical condition there. And so this document just is, to me, if I were an employer, I would be so happy to know that there is something like this out there. And last slide here is I have a rundown of a number of the types of questions that this document answers, and you can just skim through those and it gives you an idea. But again, the best thing is just click on this link and you're going to have access to the exact right place to start when you have questions about when can you test and when can you do various different things with regard to detecting and then addressing positive COVID-19 diagnoses in the workplace. All right, with that being said, we'll conclude. I'm going to check the Q&A function to see if we have any questions. It looks like we do not. So I want to thank everybody for attending. Again,
Brooke, there was a question in the chat.
Okay, let me see if I can get
the question was to confirm, an attendee wanted to confirm the information about unemployment compensation benefits and the employee not returning to work.
All right, Schaun, are you still with us?
I am.
Okay, I believe, here's the question, Schaun, and this one I believe goes to, I think it picked up on something you said. So the person writes, I would like to confirm the information regarding to UC benefits and the employee not returning to work, and that the employee is not eligible for UC benefits. Is that correct? And I'm assuming this means after a leave under the Families First Act, maybe?
It may also mean, there are some people who are out there who were told to go home initially or asked to go home for some reason and may or may not have been on the Family First Coronavirus Act and are simply afraid to return. And again, the idea that a person is afraid to return is not a reason for a person to be able to collect unemployment compensation benefits. So as the employer, you will receive a notice in the mail regarding the employee's status when when he applies for unemployment comp, and when he does, you should report truthfully that there is work available for the employee and the employer refuses to attend. If that is so, the employee will not get benefits, or at least should not get benefits underneath the Pennsylvania's unemployment compensation system.
Okay.
So there's also a form that you can fill out. It's on the Pennsylvania Unemployment Compensation website, and that form will inform the Unemployment Compensation Office that a person who is currently receiving benefits is not eligible because they've been offered a return to work. So two scenarios, right? One where the guy goes home and says, I'm afraid to come back to work. You get the notice and you go ahead and fill the information out truthfully and say he's refusing to return. The other where a person potentially, like Brook was talking about, may have been out on the 2 weeks of FMLA or 2 weeks of paid time, then is offered additional work after those 2 weeks is over and the person refuses to return, in which case you would need to go ahead and fill out new information that you would forward to the Unemployment Compensation Office. Okay?
All right. Okay, thanks, Schaun. All right, thanks for hanging in there with us, everyone. It is 12:09, so this will conclude the webinar. Watch for the future webinars that we will be presenting from the Ag Law Center. The next one that we're going to be presenting is on August, got to make sure I get the date correctly. I believe it is the 12th. And on August 12th, yes, it is, we will be doing a webinar specifically on direct sales for ag producers and the best practices and the legal landscape with regard to liability issues as applicable to direct sales. So we touched on a little bit of that here, but we're going to get into much more detail with regard to direct sales. And this could also include CSA, commodity distribution, farm stands, farmers market operations. So that will be our next one at 11 a.m. on Wednesday, August 12th. All right. Have a good day. Thank you, everybody.